quite horrified, and as I say, recording the very last part of the conversation. And as a result of that, I recall travelling to Nottingham, playing it to Mr. Clark, and relaying my recollection of the conversation and the concerns which Mr. Singh had and which I had.
Yeah. Presumably it's quite unusual for you to have recorded a client.
Very unusual. I was so concerned about what I was being told here. That is why I used my other telephone to try and record this.
Were you concerned about the potential impact on Cartwright King and their reputation?
I was concerned that it wasn't the concern about Cartwright King. Well, I suppose I would have been concerned if people were going to make allegations against Cartwright King, but I was concerned that the head of security at Post Office Limited was allegedly suggesting that the central record be destroyed.
The second point there is handwritten minutes were not to be typed and should be forwarded to the Post Office head of security. Again, is that something that you would have relayed to Mr. Clark?
Yes, he wouldn't have known otherwise.
And the third, advice had been given to Post Office, which I report as relayed to me verbatim, and we see there the words used. Again, when he says relayed to me verbatim, is that by you?
I would expect so, yes.
And that is, in fact, very similar to the minute that we saw yesterday, isn't it, from Mr. Parsons?
Yes.
Was that your intention to convey the words that had been used by Mr. Parsons in that meeting?
I think this was a general conversation because I was unimpressed with how the approach to the Wednesday morning call was changing, and I was also concerned about the conversation I'd had with Mr. Singh. So this would have been a general conversation with Mr. Clark.
So the information you're providing Mr. Clark with is not just from that conversation you had with Mr. Singh, but also, for example, the information that you obtained on the 19th of July weekly meeting?
Well, what I discussed with Mr. Singh was my perception of how things were changing. So it wasn't just discussing the report that he had received from Mr. Posnett. I was discussing also with him how the landscape appeared to be changing, and I wasn't impressed by that.
And that's number 4. Some at the Post Office do not wish to minute the weekly conference calls. Who did you have in mind there?
I don't know if we ascribed any names to that.
Thinking back to the time, who might that have involved?
Well, I do recall on the third call saying to Roderick Williams that it was necessary to maintain a central record. So I don't know whether I had him in mind at that particular point or other people, but I was quite clear on the third call that it was necessary to keep a central record. And then, of course, my subsequent call with Mr. Singh, I think, was either potentially later the same day. I think it could have been that evening.
Thank you. Let's have a look at the response from the Post Office to this advice. Can we please look at poll 00006797? I don't know if you saw the evidence of Mr. Williams or of Mrs. Crichton, where we discussed this document.
I haven't had time to watch this all the time.
So this is the response that is in Susan Crichton's name. I think Roderick Williams may have given evidence that he drafted it. I'm just going to read to you a few small passages. In the first paragraph, it refers to Mr. Clark's advice, and it says as follows: that advice was prepared as a consequence of statements purportedly made in connection with the weekly conference calls we established to share across Post Office Limited issues identified with the Horizon system. If we scroll down, we can see a paragraph there that says, Post Office Limited is committed to conducting its business in an open, transparent and lawful manner. Any suggestion to the contrary would not reflect Post Office Limited policy and would not be authorised or endorsed by Post Office Limited. Accordingly, the purported statements referred to in Simon's note do not reflect or represent Post Office Limited's position. Now, they're referred to there as purported. Was it your view that the information that had been conveyed in Mr. Clark's advice was simply purported or something that actually occurred?
I was under the impression that it had actually occurred. And now, if an instruction is sent out and emails have been sent out to numerous people, then obviously not necessarily everyone is going to react to them at the same time in the same way. But nevertheless, I was concerned that an instruction had been given and information had been destroyed.
The commitment there to openness, transparency, etc., does that reflect your understanding of the Post Office's approach at that point in time?
I think my view changed over time. There was certainly attempts to use legal privilege to cut down the amount of information which might otherwise enter the public arena. But at this very early stage, I was certainly of the view that there was going to be a single central hub of information which was going to be accurate, and I could understand the position that Post Office would wish to avoid from a publicity perspective and also a civil litigation perspective of potentially having incorrect information through supposition or guesswork entering into the public domain. So,
from your dealings with Mr. Singh at that time, Mr. Williams at that time, Mr. Scott at that time, do you think that the statement that's made there from the Post Office was an accurate one?
Not in relation to Mr. Scott, no, because why else ask for or instruct that the minutes be destroyed?
Can we please move on to poll 00325 And if we could please move on to the second page, the bottom of the second page, there's an email from Jarnail Singh to Mr. Scott and Mr. Parsons. And it relates to the weekly call. And it says, John/Andrew, I understand the remit of the above meeting was to establish a weekly conference call to act as a central hub for all Horizon-related issues. Attendees to bring all Horizon-related issues that they had encountered. Minutes were to be taken, centrally retained and disseminated to those who required the information. Most certainly, the Post Office's Horizon expert and QC would require this information. And then there's a list of various issues that had been raised at telephone conferences. And if we scroll down, there are a series of questions that are posed in Mr. Singh's email to Mr. Scott and Mr. Parsons. And he asks, who is retaining this information? Who is hunting down the issues? What has been the precise problem in each case? How was each case resolved? And the contact details of each attendee need to be circulated amongst the group. Now, first of all, does this sound to you like an email that was drafted by Jarnail Singh?
No.
Can you assist us with who might have drafted it? If we scroll up, we can see the recipients. Let me pose the question slightly differently then. Did Cartwright King draft emails that were sent by John Elsing in his own name?
There were certainly cases where emails that had been sent to John L. Singh could have been or would have been cut and pasted by Mr. Singh. But I also had almost daily telephone calls with Mr. Singh and would explain my views on things or pose questions, and it was not uncommon for those then to appear in an email.
So is it possible that this email followed either a communication from yourself by writing or by a telephone call with yourself?
It is certainly possible that this email was sent by Mr. Singh following a conversation with me, because I think I would have been concerned to ensure that the minutes, the central record was being kept.
And it's sent to John Scott, but also to Andrew Parsons, and starts with saying John/Andrew. Is there by this stage a kind of turf warfare going on between Cartwright King and Bond Dickinson?
I don't regard it as turf warfare. I felt that Bond Dickinson were perhaps having too much control over Post Office, and that's what I said to Mr. Singh when I was in the car that particular evening when we discussed the instruction to destroy the minutes that had apparently been given, because my view was that we had as a firm advised very clearly that a central record had to be kept. That advice had been accepted by the legal team at Post Office. That advice was given by Simon Clark with myself present at a meeting in Old Street. Very soon after the Second Sight interim report had been, I don't know if it's been published at that time, but we'd become aware of it certainly. But that information was imparted to Post Office. Post Office had accepted that and then set up the Wednesday morning call. And within a couple of those Wednesday morning calls, it's almost as though that requirement to keep a central record was being watered down. It was being, I took the view it was being overridden, if you like, by civil litigation objectives. Because at the very first Wednesday morning conference call, Mr. Parsons had been discussing and of course, I don't, as I've said yesterday, I don't agree with those minutes, and it's not a transcript either. But Mr. Parsons had explained from previous experience how it can generate nasty surprises when you have to do a trawl of emails across an organisation, and you can find out things that you don't know and find out things that are incorrect as well. And I didn't think from a criminal litigation point of view that would be helpful either. So I could see that he was advising from a civil litigation point of view, but by the time we got to the third conference call and there was a suggestion that actually we're going to change the way we're doing this, and I can't remember that call, but there was definitely a suggestion of a change in the way that it was going to be approached. And I felt that was effectively the influence of the civil lawyers.
If we scroll up, we can see the response from Mr. Parsons. In relation to the question, who is retaining this information, he says, minutes have been taken of each meeting along with action points. These have now been collated into the attached weekly report. If we scroll down, see what has been the precise problem in each case. And he says as follows: to the extent that details about a problem are known, these have been captured in the minutes. However, this will always be challenging because the discussions at the meetings can be quite fluid. Do you think that was a full and accurate picture that's being painted there of recording problems? Do Do you think the fluidity of the meetings hampered the minuting of those problems?
I don't think the meetings were actually that fluid. I think the meetings were actually quite structured. At times there were issues hearing people because of dogs barking in the background or other noise. But certainly that didn't jump off the page at me at the time as anything to be concerned about.
But looking at this now, does it look to you to be a fair and accurate picture that's being painted there of...
Well, looking back at this now, I don't think the minutes were that accurate. I don't think I realised that at the time. Well, I didn't realise it at the time, because generally when minutes were circulated, I simply filed them with a view to taking the view that's the central record, and we'll be instructing an expert in due course who can have access to those minutes.
Not accurate in the sense that there were typographical issues, or not accurate in the sense that they underplayed certain issues?
Not accurate in that they underplayed certain issues. And I came to that conclusion when I was drafting my second witness statement, because although I don't have the notes from those individual meetings, which I was taking myself, and as I said, I took quite detailed notes, I was able to compare the information that I think it was Mr. Bowyer had repeated in certain documents, and compare that against the minutes that had been provided, and I had more information than the minutes in certain circumstances.
Can we please look at poll 003236676? This is an email from yourself to Susan Crichton on the 19th of September 2013, and it also relates to the weekly calls. And you say as follows: Susan, many thanks for your email. I've been considering the position today, and I remain extremely nervous about having Fujitsu's lawyers on the Friday conference call. At the present time, only post office lawyers and lawyers instructed by the post office are on the call. If Fujitsu lawyers are on the call, they will have a duty to report the entire contents of the call back to their client. Whilst there may be merit in us meeting with Fujitsu lawyers if, for example, they are able to assist with disclosure, etc., I think that such meetings should be on an ad hoc basis and with very clear and limited agendas. With a conference call, there is, in my opinion, a greater risk that the Fujitsu lawyers may try to raise issues which we/you would prefer not to be discussed in front of them. In reality, was this a concern on your part that in fact Fujitsu lawyers would raise things at those meetings that you were concerned about being raised at those meetings?
No, I was actually concerned that that Fujitsu's lawyers might try and first of all push the conversation in directions which were fitting their agenda rather than post offices, and quite frankly I didn't trust them.
Were you not concerned that they might bring up issues such as the reliability of Gareth Jenkins within those meetings?
I have no doubt that that would have been probably brought up by Post Office Limited, but I didn't think that it was appropriate for Post Office Limited to discuss that with Fujitsu's lawyers at that stage. One of the concerns that I had was that I think I have an impression that in the case of Jishan Patel, which is a case we touched on yesterday, that I was told that that witness statement was coming to Cartwright King via the internal lawyers, via Fujitsu's lawyers. And of course we know that that witness statement, or I seem to remember that that witness statement, only made reference to a single bug at Callender Square in Falkirk. Now, of course, that is only one very small piece of the jigsaw puzzle. And of course, a lot more has come out since. But I was concerned about the involvement of Fujitsu lawyers at that stage.
Thank you. Mr. Smith, are we to understand from your evidence yesterday and your evidence this morning that you were in favour of things being recorded, that you were in favour of transparency, and that you, in your work for the Post Office, were not concerned about keeping things off the record?
I think generally the approach changed over time because Post Office were concerned about things unnecessarily going into the public domain. And so whilst we set out with the idea of making sure that everything was properly recorded, and I thought it was being properly recorded, in terms of transparency, I do realise that as time went on, Post Office had, if you like, a preference to avoid things going into the public domain unnecessarily, and that was pretty much driven by, I believe, the civil lawyers and Roderick Williams, who would say, well, this is a mediation case, or this is a group litigation case. Let's not make any unnecessary correspondence about this. I took the view that, well, they're the experts in civil litigation. I wasn't going to get involved with that. My concern was that there was a central record.
Do you think that over time you ultimately played a part in that lack of recording of issues to do with Horizon?
I can't think of playing a part of a lack of recording of issues.
Let's look at some documents from 2016. Can we please turn to Pol 001-39681? This is a meeting from the 23rd of March 2016. We see regular meetings in 2016. Are these now litigation meetings rather than the original weekly meetings?
No, they are if the 23rd of March 2016 was a Wednesday, that would have been one of the Wednesday conference calls. They were initially on a weekly basis, then they became bi-weekly at some point. But inevitably, there were references on some of these calls to the civil litigation that Post Office was being involved in. And I can recall Post Office wanting to be careful about, again, generating email traffic. I think at the time
I think you're anticipating the questions that I'm going to be asking.
Yeah.
So this was the weekly meeting?
Yes. Well, whether it was weekly or bi-weekly at that time, I don't know, I'm afraid. But it was the Wednesday.
Sorry, what was originally called the weekly
yes.
meeting? Yes. If we could have a look at page 2, please. We have an entry, if we scroll down from Andrew Wynne, it refers to an issue in Wimbledon, Wimbledon 119001. I think, is that a branch number, possibly? It says unpaid checks, stock line on Horizon. Branch challenged why a value showing £2,500 loss when removed, fault to be created on NBSC kit, to be corrected in the same way to see what effect this has. This theme may date back to 2005. AW, so Andy Wynne, to ask Wendy Mahoney to progress in his absence. And then it says this, MS, that's I think yourself, asked for assurance that there would have been no prosecution based on this type of incident. So there's an incident relating to a discrepancy in a Wimbledon branch, and you're asking if for assurance that there wouldn't have been a prosecution based on that type of incident.
Yes.
Yes. Could we turn to poll 0014004, 30th of March. This is the same issue, the Wimbledon transaction correction issue, and it's an email from yourself to Andrew Wynne. Andrew Wynne was one of our Phase 3 witnesses. He was in the product and branch accounting team, is that correct?
I couldn't tell you, I'm afraid. This is a long time ago.
Do you recall why you were contacting him specifically?
Well, I think that the issue having been raised on that call, I wanted to know more information because ultimately what I'm still trying to do here is make sure that we have visibility of what's happening and a central record.
And you say as follows: during the bi-weekly conference call on the 23rd of March 2016, you made reference to a branch at Wimbledon and explained that transaction corrections had been issued which should not have been issued, and that they had accordingly been undone. You went on to explain that there was a risk that transaction corrections may have similarly been issued to other branches, which may have caused losses, possibly going back as far as 2005. And then you set him a number of different questions, an explanation on the precise reason that the transaction corrections have been issued, the value, the effect, etc. 7 and 8, you ask whether this is an isolated incident or this is an issue which has or may have affected other branches, and 8, if this issue has affected other branches, the period of time over which transaction corrections may have been wrongly issued, and the names of the branches affected. So it's an issue that may go back to 2005. We're now in 2016. Can we please look at an initial response, which is at poll 00153939, 5th of April 2016. It's a response from Wendy Mahoney, Case Review Team Leader, and she says as follows. She says, I'm covering for Andy at the moment. Please find responses to the first 6 questions. Questions 7 and 8 will take slightly longer, as I will have to obtain information from different departments within the post office. If we scroll over the page, please, to page 2, we can see her initial responses. If we scroll down, question number 3, where you requested the effect of those transaction corrections on branch accounting, the response was it doubled up the discrepancy from £2,400 to £4,800. So quite significant information there about a bug that is doubling the discrepancy in the Wimbledon branch.
Yes.
And we see there 7 and 8 at that point had not yet been answered. We then go to the further response from Wendy Mahoney. That's at poll 00241095. 26th of April 2016. She says, hi Martin, FSC have now provided an update on questions 7 and 8. Please see narrative and table below. If you require any further information, please let me know. Now, it may be that you're not able to assist us with exactly what this all means, because it does look quite complicated, but the first paragraph says, I've looked into the unpaid check GL for all items that have been posted since 2010. This resulted in 15,000 plus items. She says that they were looked at, but then she goes on to say, however, system archiving at 13 months meant that a large number were unavailable to investigate. So there seemed to be some sort of time limitation on that investigation. Do you recall that at all?
I'm afraid I don't recall this now.
She then says, I then moved on to the actual transaction corrections that had been issued and read individually the text detailing the cause of the transaction correction. From this, I managed to pull out the details for the archived items. Results as below for all transaction corrections issues 2010 to current date. And then there's a table underneath, and it says transaction corrections issued, not compensated, that feature the same issue as the Wimbledon list below. And there is a list of various branches that had been affected by this issue. Do you remember being concerned about this?
No, and I think this fell during a period just after I had left Cartwright King. If we can go back up to the top of the page, you'll see that the email that, sorry, the
26th of April.
the one I sent initially was at the end of March, and I believe that I left Cartwright King at the end of March, which is, I think, one of the reasons why I copied in Simon Clark and Harry Bowyer, who were remaining at Cartwright King for a period of time. And then, at some later point, we commenced, or we certainly commenced working for Cartwright King on an agency basis. So I think this perhaps fell into a gap just after I'd left.
So when you say you left, you set up a company with Mr. Bowyer and Mr. Clark?
We did, and I remember that I left Cartwright King a month before they did. Oh, I believe that I left Cartwright King a month before they did. I think I left Cartwright King at the end of March.
Okay, well, we'll have a look and see what capacity you may have been in attending various meetings. But are you saying that you don't recall receiving this information?
I don't recall this information. I'm not saying that I haven't seen it at some point, but I don't recall that information. And it may be that be down to the fact that I left.
Well, let's look at the various meetings that you are present at throughout May, and we can try and work out in what capacity. Can we please look at poll 00120311? This is a meeting of the 4th of May, and it has you down there as Martin Smith of Cartwright King.
Yes.
Were you still at Cartwright King on the 4th of May?
So I wasn't an employee of Cartwright King on the 4th of May, but we were working on an agency basis for Cartwright King.
Were you still acting for the post office?
Cartwright King was still acting for the post office, yes.
Were you still acting for the post office?
Well, I was certainly attending these meetings. I don't know whether I had access to my emails at this point in time.
Were you still acting for the post office?
Well, yes.
Roderick Williams is down under legal as well. We see somebody called Shirley Hailstones under support services, if we have a look down. Thank you very much. Can we look on page 2, please? Under Wimbledon. SH, so Shirley Hailstones. Do you recall Shirley Hailstones at all?
I recognise the name.
Seeking clarification of the figures, MS, which is yourself, saying that there was limited information available as data only presents for the last year and a half. See, that seems to be a recognition of some of the information in that previous email that referred to data only being held for 13 months.
Yes.
Do you recall being in possession of information about limited data being available?
Well, I must have seen some information, but how it came to me, I don't know.
The recent data suggests false balance issues, and therefore it will be useful to look into older data as well. SH asking who should make the decision about looking into older data. MS, that's yourself, saying that RW, I think that's Roderick Williams, could give the go-ahead. You will liaise directly with Mr. Williams outside of the meeting. It then says Mr. Williams is happy with this, but also emphasising that this matter is subject to the group action and data could be disclosable. Roderick Williams asking for no email traffic on this matter. Do you recall Mr. Williams saying no email traffic on this matter?
No, I don't.
Do you think that that was a proper request to make?
If his concern was to avoid emailing various different people and then incorrect speculation, then I could understand why he would want that in. But I was concerned that there was a central record. As far as I was concerned, this was now on the radar, and it would be open to an expert instructor to look into this.
And the concern there is that data could be disclosable, therefore no email traffic. Do you think that that is proper?
Again, that's civil litigation, and I took the view that that was Roderick Williams' domain and nothing for me to comment on.
Why were you at the meeting?
Well, this was a Wednesday meeting, so it was collecting information relating to the Horizon system.
Did you not have any views on whether or not there should be email traffic on a bug in the Wimbledon branch that's affected a number of different branches?
The issue had been flagged up, and there was information there.
Can we look at poll 000434335, meeting of the 18th of May? You're still present there, still referred to as Cartwright King, although, as you say, you may have been acting in your firm with the other two previous Cartwright King lawyers. If we scroll down, please, to the bottom of page 2. New issues identified. MS, that's your initials. Cartwright King. Issues, observations, comments. Wimbledon can be taken off this agenda. Martin and Roderick catching up offline. It looks very much like you followed Roderick's request not to correspond on that issue. Is that right?
It may be that it does look like that, yes. But again, as far as I was concerned, this issue had been flagged up and it was now in the central record. If Roderick Williams did not want additional material preparing from a civil litigation perspective, that was his call, not mine.
Mr. Smith, after all that you've been through, after all that we discussed yesterday, finding out about unreliability of Gareth Jenkins, finding out about bugs, errors and defects that hadn't been disclosed in criminal proceedings, proceedings that you were involved in, proceedings that led to the imprisonment of a sub-postmaster, finding out about a request for Mr. Scott to shred documents or destroy documents. Surely you couldn't have thought at this point in time that catching up offline about an issue relating to a bug was an appropriate action to take.
When it says offline, it's not offline completely. It's just simply not within this call.
Is that really your evidence?
Well,
There was a meeting, the previous meeting, where Mr. Williams asked for no email traffic.
yes. Well, at the end of the day, he is the client. He is saying, I do not want any email traffic. This has been flagged up. It is now in our database. It's now in the central record.
And you're having private meetings that no electronic record is being kept of.
Well, it wouldn't be in an email, but I would have had notes in my notebook.
So you were keeping a fully disclosable note of this issue.
I was keeping notes.
And were you providing that to the central hub?
No, they were my personal notes. I left the notes that I made at Cartwright King remained at Cartwright King. Now, this is after I left Cartwright King, but I was still keeping notes.
So what's the purpose of the central hub if you're keeping notes that are kept in your office that aren't in the central hub,
Well,
and that you're corresponding offline?
The central hub is to be able to provide information to anyone who needs it. My notes were an aide-memoire, so I could quickly look at things.
You were discussing a bug in Horizon that was affecting branches and causing discrepancies.
But it's been flagged up in the hub.
It's been flagged up, but the discussion about how long it's been going on for, whether it affects prosecutions, none of that's in the hub, is it?
Not on the basis of this record, no.
The answer to the questions you were asking earlier, does it affect prosecutions, it's being dealt with offline.
I don't believe that I thought of it in that way at the time, because the file review process had been completed. Disclosure had been made to those whom senior counsel had advised it be made to, and we had been informed that we did not need to go looking for cases prior to the 1st of October 2010. So this was something that had been flagged up. It was something that an expert could opine on in due course.
Can we please look at poll 00120321? This is a meeting of the 1st of June 2016. If we scroll over the page to page 2, now it says MC and RW agreeing this matter can be closed. On the minutes, MC seems to be Melanie Caulfield, who is in the communications team. Do you think that might be a typo and it might be your name, or do you think she, in fact, agreed with Mr. Williams that the matter could be closed?
I really don't know whether that's a typo or not.
Would it be odd if somebody from the communications team agreed that an issue relating to a bug could be closed?
I don't know if Mr. Williams had involved that lady in that discussion.
Can we please now turn back to a document that we saw at the very beginning of yesterday, and that's poll 004-11347. And that's the advice that you gave in the ongoing criminal matter of Zen Elvins. And could we please turn to page 3? This isn't 2016, this is 2015, but it's similarly late in the picture.
Yes.
And this is paragraph 9, so if we scroll up, where you advised that whilst this is not a Horizon issue, to the extent that the system permitted the sequences of transactions in accordance with its programming, it does not, of course, make the position any less embarrassing for Post Office Limited. But there is, in my opinion, a substantial risk that any reports generated by a prosecution in this case may be utilised by those who seek to argue Horizon is defective or otherwise inadequate. By this stage, so 2015, going into 2016 and those meetings that we've been looking at, were you concerned about embarrassment being caused to your client, the Post Office?
I felt that it was our duty as instructed lawyers by them to flag it up.
Did you think perhaps that by 2016, when you were setting up a new firm, that it was important to keep the Post Office on side and to follow orders not to discuss things online?
I took the view that the civil lawyers would be making decisions in relation to civil litigation, and I didn't question their decisions.
Thank you, that can come down. I'm going to move on to a few miscellaneous topics before handing over to core participants. The first is remote access. I think we can take this relatively quickly because a number of witnesses have recently been looking at the same documents that we will be looking at. But can we start with poll 00141471? And we're going back in time now to November 2012. And could we start on page 4, please? At the bottom of page 4, we have an email from Rachel Panter to Gareth Jenkins, and she is seeking his report, Mr. Jenkins' report in the case of Kim Wiley, and it's urgent because the case has been listed. If we scroll up, there's a response from Mr. Jenkins. Paragraph 3, he says, reading through the defence statement, I see it does make some specific points which my statement doesn't currently address, specifically the challenges regarding robustness and remote access to the system. Do you want me to try and address the specifics? If we can go to page 3, Ms. Panter responds, copying you in, and she says, if you feel that you're able to deal with the issues of robustness and remote access fairly swiftly, then I would like you address these points that have been raised so that we can deal with every area that they have criticised. Can you assist us with why you're copied in? Were you supervising Rachel Panter or working with her on the case of Wiley?
I don't believe I was working with her on the case of Wiley. I think that was one that Mr. Bowyer was dealing with. Mr. Cash, of course, was the at that point the partner in charge of the Derby office and the partner in charge of the post office department.
If we scroll up to page 2, please, Mr. Jenkins responds. And he says, Rachel, what I propose adding is the following. I've been asked to provide a statement in the case of Kim Wiley. I understand that the integrity of the system has been questioned and that this report provides some general information regarding the integrity of Horizon. There's then a paragraph that addresses the integrity, and I want to look at the paragraph that addresses remote access. It says, I note a comment made about it being possible to remotely access the system. It is true that such access is possible. However, in an analysis of data audited by the system, it is possible to identify any data that has not been input directly by staff at branch. Any such change in data is very rare and would be authorised by the post office. As I have not had an opportunity to examine data related to this branch, I cannot categorically say that this has not happened in this case, but would suggest it highly unlikely. You, I think, have said in your witness statement that it's in a small font and you don't believe that you read the email.
I didn't read that in full at the time, no. And first of all, it wasn't a case that I was dealing with, and secondly, it was in a very small font, and I think it was also dealt with by Mr. Bowyer very quickly.
When you say it was dealt with very quickly, I mean, that ultimately ended up in the witness statement.
It did, but I think the response to Mr. Jenkins was very timely.
Let's move on to the Deloitte report. That's poll 00028062, 24th of May 2014. Page 31, please. I don't know if you were watching Mr. Oyard this morning, but this is a section I think that he was taken to.
I saw part of it from the waiting room.
Thank you. So it's the bottom of page 31, and there's various references there to the ability to insert what's called balancing transactions. A method for posting balancing transactions was observed from technical documentation, which allows for posting of additional transactions centrally without the requirement for these transactions to be accepted by sub-postmasters. and there are various concerns raised there about the controls that are in place to monitor that. We then have an advice written by Mr. Clark, that's Pol 000217774. And this is an advice that has Mr. Clark's name at the end, 27th of March 2015. And he refers, if we scroll down, we can see there, paragraph 2, the reference there to parts of the Deloitte report. You've said that you don't recall this advice, but were you in any way assisting with the drafting of this advice?
It wasn't uncommon for Mr. Clark to run an advice past either myself or one of my colleagues to talk through it, to explain his methodology, his thought process. I may have seen it, I don't recall.
Often in his advice he writes, "we have seen," or "we have done this or that." Is that because he has discussed it internally?
I've never really given that any thought. It may just be his house style.
If we turn to page 2, there's reference to a telephone call with Roderick Williams and Andrew Parsons. We were informed that the Deloitte report was correct where it identifies a method of posting of balancing transactions. Were you part of that telephone conference?
I have no recollection of that, I couldn't say.
If we move on, please, to Pol 0002987, 15th of July 2015, there's an email from Andrew Parsons. Now, it's to yourself and Simon Clark, and it relates to balancing transactions, so that is the ability to inject transaction data by support staff. And he says, "Martin, Simon, before Roderick went on holiday, he asked me to push forward the disclosure piece around balancing transactions. I understand that during the conference with Brian Altman, there was a discussion about doing some further investigations into when Post Office had used BT's balancing transactions on old Horizon, so that's what we know as legacy Horizon. As part of these investigations, we asked Fujitsu to explain how balancing transactions would work on old Horizon, and essentially it is possible to do the equivalent on legacy Horizon." He then says, "It has subsequently been confirmed by Fujitsu that searching for balancing transactions would in fact be an enormous task, taking several months of work." And he ends that paragraph by saying, "On this basis, the Post Office is not prepared to commission this exercise unless it is considered absolutely vital and there is no credible alternative." Now, given that you can't recall whether you're part of that earlier conference, that you can't recall the email from Gareth Jenkins that relates to his evidence on balancing transactions, why do you think it is that Andrew Parsons names you as the primary recipient, the first named individual on this email in relation to the issue of balancing transactions?
Well, I may very well have been involved in the call. I just cannot remember it.
Might you have thought at the time that the ability to inject data by support staff was something quite significant?
I was under the impression that Mr. Clark was reviewing this and advising Post Office in relation to it, and I was letting him take the lead.
Why do you think Mr. Parsons is saying there, "Martin, Simon"? Why would he have the impression that you were at least jointly involved, if not the principal person to contact?
I was often the point of contact at Cartwright King, whether I dealt with something or not. And it wasn't uncommon for me to receive something and then pass it through to either Simon Clarke or Harry Bowyer for their attention. And it may be that I was involved. I cannot recall.
By 2015, you were very experienced. It's not like you had to follow Mr. Clarke in what he did.
By 2015, this had been going on for quite some time. It was virtually impossible to remember everything that had happened beforehand because this was a whirlwind. I certainly couldn't recall the issue with Mr. Jenkins talking about remote access arising at that earlier stage. That wasn't something that was springing to the front of my mind. It just simply wasn't on my radar.
Is there anything you recall about the Post Office's approach to remote access during this period?
I recall Mr. Clarke advising that in order to determine whether or not it was going to be disclosable, further questions ought to be asked.
Did it cause you any concerns about all those cases that you have been prosecuting over the years?
Well, I don't think it did when I first became aware of the issue, because I didn't think that anything sinister would be happening. I mean, after all, you know, this is the Post Office, this is Fujitsu. Why on earth would you think that things that were sinister would be happening?
I'm going to move on to the issue of Gareth Jenkins and expert evidence. You've addressed it in your statements.
Yes.
Were you aware throughout the period that we have discussed of the various requirements that are legally in place with regard to the instruction of expert witnesses?
I have to accept that I wasn't. Like I said yesterday, we had essentially been a defence firm of solicitors. We had presented cases in court on an agency basis, and as I pointed out yesterday, there is a world of difference between doing that and actually progressing prosecution files. Quite why Cartwright King thought it was appropriate to take on this prosecution work, I really, with hindsight, have no idea, because we certainly didn't have the training for it, and I was unaware of the duties on a prosecutor in relation to the instruction of an expert witness.
By 2012, you had been qualified for 16 years.
Yes.
Do you think it is unusual that you weren't aware of those kinds of duties?
I was simply just not aware of the duties on a prosecutor to actually make sure that an expert witness was fully informed of their duties, etc. It was clear from when Mr. Clarke wrote his advice that we had been seeking reports from Mr. Jenkins in a way which perhaps was not, well, undoubtedly was not compliant.
Did you ever see formal written instructions to Mr. Jenkins?
By formal, in terms of a letter setting out all of that, no. Our approach had been that Mr. Jenkins had clearly been used as an expert witness in the past by the Post Office. Mr. Bowyer advised about the content of a generic expert report, if you like, that should be used as a baseline. And we then went from that point onwards, and no formal letters of instruction were provided.
Did you consider whether his witness statements complied with various legal requirements?
No, I don't believe I did. I took the view that we'd been advised to obtain a Section 9 statement, and that's what we prepared, and we sought to update it in cases in which there was a not guilty plea. I don't believe that I gave it any more thought than that.
At one point you became involved in discussions relating to the instruction of a new expert or experts, Professor
Yes.
Kramer and Dr. Dooley.
Yes.
Can we please look at a few documents in relation to that matter? They can be found at Pol 00148,714. If we could start on page 3. How did you become involved in seeking out a new expert?
I think that probably came out of one of the very early conferences at Hull Street with Susan Crichton and others from the legal department after we'd become aware of the Second Sight interim report making reference to bugs. I don't think at that stage we necessarily knew about all of the information relating to those bugs. But Mr. Clark's view was that as they had not been mentioned by Mr. Jenkins, it could no longer be, Post Office could no longer rely on his evidence, and a new expert would be required. And I think, from memory, I think it was Susan Crichton asked us to see if we could find a new expert. And I think one of my colleagues actually prepared a short list of potential experts looking at various organisations around the country. But then ICL, I think, became the favourite.
Can we please scroll down to the bottom of this page? It's an email from yourself to Andy Parsons, the 9th of July 2014. And you say as follows: I would not advise that the experts be instructed to look at the old Horizon system. If the experts were to consider the old system, depending on their findings, disclosure issues could arise in historic cases. In any event, cases now being investigated and considered for prosecution will involve Horizon Online, which was rolled out during 2010. Can you please assist us with the first part of that response with regards to disclosure issues? What did you mean there?
Well, I think at that time we were being informed that the old legacy Horizon was no longer available in any way, shape or form to be tested, and important information relating to its design and functionality was no longer available. I couldn't see how any expert could actually then say, well, we've looked at the system and the system was fine. Any report that they would produce would have to be caveated incredibly. And then if there is a report that tells Post Office, I'm sorry, we cannot say anything about the legacy Horizon system, what sort of position does that put Post Office in? I was also aware that Simon Clark had advised that the experts should only consider Horizon Online, and I believe that Mr. Altman, King's Counsel, had advised similarly.
Mr. Smith, surely that second sentence relates to potential issues for cases that had been prosecuted if the experts were to find problems with Old Horizon. Surely that's the only interpretation you can have of that second sentence.
I can see how it looks, but no, I was concerned that the experts would not be able to look at the system properly, and I could see that there could become all sorts of issues arising if they provided a report that basically said they could not, for reasons beyond their control, provide any certainty with regard to the old Horizon system.
Disclosure issues.
So if there was a report that was provided by Imperial College London which said that we cannot confirm that the old system was, and I'll use the phrase, robust, then that potentially would have implications in relation to every single prosecution.
If they didn't have enough information to say whether or not the system was robust because they didn't have access to the information because it was historic, you think that that could lead to problems with historic cases?
Well, yes.
Were you not more worried about the fact that they could investigate the old Horizon system and find a lot more bugs, errors and defects?
Well, I didn't think they could investigate the old Horizon system because it wasn't there to be investigated. Didn't exist any longer, and the information which related to it, I understand a lot of that key architecture information had gone. And I also understood that a lot of information related to historic prosecutions had gone through data retention policies.
If you thought that they couldn't investigate the system because the material wasn't available, it's a very odd way to start by saying if the experts were to consider the old system, isn't it?
Well, I think I would have read that as if the experts were asked to consider the old system.
Well, come on now. You're a lawyer writing to a number of other lawyers, and I think I can reasonably infer that you would write reasonably precisely in these circumstances. So why are you beginning this sentence on the premise that there could be a consideration of the old system?
Well, there could be a consideration to some limited degree, but it would be very limited.
You're adding words, Mr. Smith.
Sorry?
Those words don't appear at all in this email. Why should I assume or decide that you wrote an email which had more or less a completely different meaning from the one which is obvious reading this?
Well, I don't think it is different. I mean, there would be disclosure issues which could arise, but in any event, we were now looking at the new system, and Council had advised that we did not need to go looking for cases prior to 2010.
All right.
That was Mr. Altman Casey's clear advice that Post Office did not need to go looking for cases prior to the 1st of January 2010. And in those circumstances, I could not see any merit in asking an expert at considerable expense, contrary to the advice of Simon Clarke, which was to focus simply on Horizon Online, why we would ask the experts to look at a partial amount of documentation relating to its design and no ability to actually test the system. I could not see that sort of report would be helpful at all, and could see that would be a nightmare situation.
Okay, I'll move on to the issue of disclosure post-conviction. We've heard a lot of evidence from you about, we've spent a lot of time on the disclosure during, for example, Mr. Ishak's trial and during the trial process, but I want to move on to disclosure post-conviction. Can we please look at poll 00006581? And the issue is disclosure during the mediation scheme and to Second Sight. And this document that I'm taking you to is the Altman General Review. It's the 15th of October 2013. Can we have a look, please, at page 42? Mr. Altman records as follows in his advice. He says, during the telephone conference of the 4th of October 2013, the main topic of discussion was the extent to which Cartwright King should be involved in exercising a supervisory function over the criminal cases going to mediation, such as Mrs. Misra's case. There is understandable concern that offenders might use the mediation scheme to gain information as a platform from which to launch a fresh or new appeal. And so Cartwright King wished to exercise a measure of control over the dissemination of information and material during the process. Were you part of that telephone conference on the 4th of October 2013?
I cannot recall. I may have been. During this period of time, there were numerous telephone calls on different days.
And there seems to be a concern from Cartwright King as to cases that they had been prosecuting and potential disclosure to those who they had been prosecuted. Do you recall conversations of that nature?
I don't agree with the way that that's phrased, if I may say. I can recall that when the mediation scheme was started, it was not ourselves that were raising concern. It was Post Office that was initially raising concern that concessions could be made or throwaway comments could be made which might provide a mediation scheme applicant with some form of ammunition to argue that for example, the case being presented by Post Office at that stage was different to the basis upon which they had been prosecuted, whether that had been by Cartwright King or indeed by the Royal Mail Group sometime previously. So I think it was initially Post Office that were concerned about the convicted applicants in the mediation scheme and the information provided to them. I think that's where the concern.
So you think that is wrong there, if it is to be read as suggesting that Cartwright King were concerned about people that they had prosecuted launching a fresh or new appeal?
I don't think it's a case of Cartwright King being concerned about the people that they had prosecuted. As I say, the concern was initially by Post Office in relation to blanket convicted applicants to the mediation scheme, irrespective of whom they've been prosecuted by. And I understood that Mr. Bowyer and Mr. Clark were able to understand that concern, and in fact, I think Mr. Clark advised in relation to it.
Why Mr. Bowyer and Mr. Clark? I mean, were you not a 3?
We were a 3, but the general way that we dealt with this was to have advice being provided by senior counsel.
You often,
Post Office was...
Throughout your evidence, have been referring to Mr. Clark as being senior or more experienced than you. All of the emails that we've seen, there isn't a single one there that seems to distinguish in your seniority or abilities.
No, I was generally the main point of contact, but I have seen in the papers that have been provided, and I'm sure you will have seen them, there is evidence of me forwarding things to Mr. Bowyer to look at. There's evidence for me forwarding things to Mr. Clark to look at. I was the point of contact, and indeed in relation to the mediation scheme, I think it was agreed that there should be one point of contact at Cartwright King for all of the traffic to go through, and one point of contact at, I don't know if it was Bond Dickinson or Womble Bond Dickinson at that time, but one point of contact there. So that way it would keep lines of communication clear rather than different emails being sent to different people.
And that one point of contact was yourself?
And the one point of contact was myself at Cartwright King for virtually everything, irrespective of what it was.
So in that case, it's highly likely that the telephone conference that took place on the 4th of October involved yourself?
It may well have done. I can't remember it.
Can we please turn to poll 001688949? And can we start at page 2, please? This is the case of Noel Thomas that's being looked at. We've heard from Mr. Thomas. He was sentenced to 9 months imprisonment. His case is being looked at in May 2014. You were sent Post Office investigation reports, which in turn would be sent to Second Sight. And there's an email here from yourself to Andrew Parsons. And you say as follows: whilst we have advised that as a matter of principle, investigation and offender-type reports should not be disclosed, I understand that there will be circumstances in which it is felt that there is no alternative other than to disclose these. In such circumstances, they should be appropriately redacted. If you would like me to deal with that, please let me know. So was it your view, as at May 2014, that the investigation or offender reports into those who have been convicted, like Mr. Thomas, shouldn't be disclosed as a matter of principle?
That was the advice that I received within Cartwright King, yes.
When you say that was the advice you received within Cartwright King, Mr. Smith, you are a lawyer from Cartwright
yes.
King. You are communicating with the client, Andrew Parsons, that is surely your advice.
It is also my advice, but that was the strong views of Mr. Bowyer and Mr. Clark, and I accepted that. And
Mr. Smith, you
we
weren't on
present-
work experience with Mr. Clark.
No, I
and
wasn't,
Mr. Bowyer.
but I was aware that they had a substantial amount of experience of prosecution cases, far more than I did, and I was content to follow their lead.
If we turn over to page 1, please. Mr. Parsons says at the bottom of page 1, thanks, if you could mark on the docs any bits that you would prefer to be redacted, that would be great. And you respond on the top email. You say as follows, Andy, please find attached the investigation reports on which I have highlighted in black the parts which I would advise be redacted. Consequently, I have also further amended the draft report in light of the redactions. I'm just noting here, it's several I's, so that there's no we.
No, it's
in
not
this
we,
email.
it's I, yes.
I would prefer not to let the applicant see the sentence in Diane Matthews' report of 25th of October 2005, which notes that she was currently awaiting the results of the tests by Fujitsu on the Horizon system if those test results cannot be found. Such a sentence may well invite a request for disclosure of the test results. There may also be a risk that the applicant will suggest that the investigation was inadequate or incomplete. Similar issues could arise out of the comment on page 7 of the draft report. However, it appears that the kit was taken by Fujitsu to allow the equipment testing to be undertaken. No documentation is available in relation to this. On what possible basis could those redactions be justified?
I really don't know. Looking at this with hindsight, I don't know.
I don't think you need hindsight to
Well,
reflect on this. Perhaps on reflection.
On
it's
reflection,
correct.
I was of the view that information which might put into the public arena the sorts of investigation work carried out by Post Office or sensitive methods or opinions should not be disclosed.
What's sensitive here? What you're saying here is that they should be redacted because they may lead to disclosure requests. What's wrong with disclosure requests being made by those who are convicted of criminal offences, some of whom were sent to prison?
Yes, I clearly got that wrong.
It's
I mean, as a firm, we took the view that anything which contained the opinion of, for example, an investigating officer about a witness or something about a method of investigation or something sensitive should be redacted. But I cannot see here, on reflection, anything which sensibly should have been redacted.
wasn't it part of a culture of withholding information from applicants?
Not intentionally, no.
Can we please look at poll 00325867? It's the bottom email from Mr. Parsons to Chris Oyar, Roderick Williams, a team at the Post Office, copy to Simon Clark and yourself. He says as follows: I've just spoken with Cartwright King about the new, that's a questionnaire from Howe & Co. that references the Helen Rose report. These are questionnaires that are filled out by applicants to the mediation scheme.
Right.
You will recall that the Helen Rose report was retrospectively disclosed in a number of prosecution cases as it drew into question some of the statements made by the Post Office's expert witness, Gareth Jenkins. A copy of the Helen Rose report has made its way to Howe, who are now referencing it generally in their questionnaires. For example, the questionnaire in MO60 refers to the Helen Rose report. However, the Helen Rose report was not sent to this applicant. The point of concern is that the MO60 questionnaire is starting to make the link between, one, the fact that the Helen Rose report makes clear that Gareth Jenkins knew of issues with Horizon, and two, the fact that Gareth Jenkins never mentioned these issues in his prosecution evidence. See para 53 in the attached. This line of inquiry draws into question the credibility of Gareth Jenkins's evidence. And that's precisely the concern that was raised in Mr. Clark's advice a year before that, isn't it?
It is.
It then says, the sharing of the Helen Rose report between applicants is potentially a breach of solicitor's ethics / contempt of court. However, Cartwright King, and I don't believe attacking the solicitors on this point would be of benefit. If anything, it may draw more attention to the Helen Rose report. Instead, our preferred approach is to try and downplay the importance of the Helen Rose report in any Post Office investigation reports. We recommend minimising or ignoring entirely the Helen Rose report when responding to questionnaires. If the investigation team need guidance on how to address any Helen Rose report related questions, I suggest they or the lawyer here at Bond Dickinson addresses these directly with Cartwright King on a case-by-case basis. Please let me know if you're happy with this proposed approach. Martin, Simon and I are available if you have any questions. Do you consider that to be an appropriate approach to the mediation?
The lawyers at Bond Dickinson were advising Post Office in relation to the mediation. How they wished to deal with individual mediation applicants was a matter for them.
Why is your name on this email?
It's been sent through to us.
Why does it say Martin, Simon and I are available?
Well,
Is Mr. Parsons entirely wrong? This is a Bond Dickinson affair, not involving yourself.
No, we looked at proposed responses to mediation applicants. That was Cartwright King's role, and as it points out here, the Helen Rose report started to become mentioned by other applicants. Post Office clearly didn't wish to explore that with a number of applicants, but that was their decision. We were not advising Post Office how to conduct the mediation process, and that was, in my understanding, was a matter for Bond Dickinson.
Mr. Smith, you had been advising the Post Office for years. We saw yesterday the proposed response to the CCRC, who were interested in matters after the second site report. We've seen in various places that crucial link between the Helen Rose report, Gareth Jenkins' evidence, the fact that Gareth Jenkins didn't mention certain things in his prosecution evidence. That crucial link has not been mentioned by the Post Office. And here there is discussion involving you as a key contact seeking to downplay the importance of the Helen Rose report, recommending minimising or ignoring entirely the Helen Rose report when responding to questionnaires. Do you think that that was appropriate?
I'm not aware that Cartwright King were involved in downplaying that.
Did you respond to this email saying that is grossly inappropriate, we want nothing to do with it?
I don't believe I did. I don't recall this email.
did you respond to this email, noting that your name had been mentioned in that final paragraph as a key contact, and saying that I'm nothing to do with this?
No.
You don't remember receiving this email. Do you remember the issue being discussed?
Not this specific issue, no.
If we scroll up, you're one of the copy recipients. He says, I've just spoken to Cartwright King. Not you?
I don't recall this. I'm sorry, it's a long time ago. I just simply do not recall this.
So I think that might be an appropriate time to break. I'm glad to report that I only have about 15 minutes left after lunch, and then we can move on to the core participants who have all been given allocated times.
Jolly good. Then what time shall we start?
Can we start at 1:55, please?
Yeah, by all means.
Thank you very much.